matter of HEB Enterprises Limited and another Respondents versus Bernice Richards as personal representative of the estate of Anthony Richards, deceased appellant. Please be seated.
Carry on.
Yes, Mr. Watson.
Good morning, Lords. I appear with Mr. Kennedy for the appellants, and friend Mr. Robinson, King's Counsel, appears with Mr. Anson Holland for the respondents. To give you an idea of where I'm proposing to go in the time allotted to me, I propose to make two short observations, first by way of overview on the appropriation by the Court of Appeal and the respondents, and second on the breach of contract giving rise to this claim. Secondly, I'm going to deal briefly with the authorities on the law of restitution to make good the proposition that any restitutionary analysis, particularly one involving failure of consideration or failure of basis, must start and will in most cases end with a detailed consideration of the parties' contract. Third, because both the Court of Appeal's analysis and the respondent's alternative analysis deal in detail and rely upon the terms of the contract to deal with those contractual terms. Fourthly, to look at the analysis of the Court of Appeal and why we say they went awry. And finally, to deal with the respondent's alternative case, which is to treat the interest component of the payments as effectively an occupation rent in respect of which the consideration didn't fail. And that will be something that, if I don't get to the end of, I suspect I will be revisiting in points of reply anyway, because I suspect my learned friend will be dealing with that in rather more detail. In terms of introductory observations, there are two analyses put forward to say that we should not have the return of interest as well as the return of principal following the termination of these contracts. First, the Court of Appeal's analysis, which is by way of restitutionary credit. It's not entirely clear quite how that arises. And it's one that we say rewrote the parties' contractual bargain and overrode established principles of the law of restitution. In substance, we say that the Court of Appeal considered that the parties had reached a rather bad bargain and sought through the law of restitution to improve it in a manner that we say was impermissible. And second, there is a case pursued with rather more vigour, which is that there was no need for the Court of Appeal's analysis because effectively interest was a form of occupation rent under the contract, which we say ignores the fact that possession wasn't granted under the contract, ignores the allocation of risk under the contract, and is based on a statement of the law of Victoria, which, from looking at the authorities provided, doesn't appear to necessarily be the law of Victoria. It isn't the law of the Cayman Islands, and it doesn't apply to a contract such as this in any event, because it applies only where the purchaser is entitled to possession, whereas my clients were never entitled to possession. The second introductory observation relates to the breach, and to put in context the claim that was pursued in the Grand Court. As at the date of termination, my client was really rather close to paying off both. In relation to Shop 10, he was $6,252 short of paying it off. And it was also said there was a certain amount of interest outstanding of around $3,000. In relation to Shop 11, there was a minor dispute in the Grand Court, but he was in the region of $25,000 short of paying that price off as well. And if he had been able to pay those amounts, and his evidence was that he truly desired to, because these shops were to be his pension, there would have been no question of restitution. The buyer would simply have obtained the sums due under the contracts, and that would have been the end of the matter. He sought to ensure that that the seller was fully compensated under the contracts, and you can see that at page 690 of the electronic bundle. A letter written on the 29th of March 2016 from his then attorneys Sampson and McGrath. You can see that it recites that there was an offer and that the contracts had been entered into, and that in the middle of the page our clients paid all principal sum due under the contract barring the following amounts: $23,000 on Unit 11 and $6,000 on Unit 10. Noted below, our client has entered into binding agreements to sell the 2 units to a third party for the combined sum of $390,000, with closing to take place on or before the 18th of April 2016. It's proposed that at closing you will sign off on RL1 transfers for both units in exchange for the sums owing at that time on the contracts being at present $30,095.65. And then notes that there was a dispute in relation to strata fees. We're aware that you claim that you're owed the following sums: $41,000 in strata fees and late fees of $3,653, and notes that $15,000 is owed to the strata in respect of overdue strata fees for the units. And then over the page it notes that there is a dispute, and unless the parties can compromise those claims within the next 28 days, that would have to be determined by the Grand Court. But in the interim, and to allow the sale of the units to go through, we suggest the following holding position: that as the net proceeds of sale, $15,000 owed to the strata would be paid, and the remainder would be held in escrow until determination of liability. And there was no acceptance of that offer, and instead, on the 18th of April, the contracts were terminated by Mr. Bob. So we say that that's important because insofar as it is said against me that there is any injustice arising out of a claim for return of the monies paid, not only is that a result of Mr. Bodden's election to terminate the contract, but there was a real prospect of him being paid everything he was due under the contract. And while he was entitled to terminate, that has to come with an acceptance of the restitutionary consequences of termination, we say.
If it assists you, Mr. Watson, it may be that if one leaves aside for the moment the analysis that the Court of Appeal preferred, there might be thought to be a rather short point of construction of a contract here. As I understand it, your approach proceeds on the basis that the capital instalments and the interest on the balance outstanding from time to time constituted the consideration for the sale. The sale didn't proceed, and therefore you're entitled to the return of the consideration for which you received nothing in return. The opposing argument is that in reality the installments of the price were the consideration for the sale. The interest on the balance outstanding constituted consideration for possession. You did not receive anything in return for the capital installments, and therefore on rescission are entitled to the return of those, but you did receive possession, which, if it was the consideration for the, if the interest was the consideration for possession, then you wouldn't be entitled to that. So, there would appear to be a pretty short question of interpretation of a contract, which one could put as being whether the consideration is severable and attributable to sale on the one hand and possession on the other hand, or is the consideration entirely in respect of the sale.
Yes, yes, absolutely. I quite agree. On the apportionment case, if I might term it like that, it is absolutely a very short point of construction, and one we say is answered by the fact that there was no right to possession under this contract.
Yeah, I mean, if you lose on the point of construction, that seems to be the end of it.
Yes.
If you win on the point of construction, then I suppose one might then have to consider the argument that appealed to the Court of Appeal, that it would be unjust to allow you to have the benefit of possession free, and on that basis they took the view that there should be a set-off for mean profits limited to the amount of the interest. So they arrive at the same outcome as if the consideration were severable, but by a different process of reasoning.
Yes, albeit that the Court of Appeal's analysis was that you would have to deduct the value of the occupation assessed by way of mean profits, which would have been higher. In fact, if you take the value of mean profits, it would have wiped out all of the payments. There would have been nothing due. But they said that it was subject to the concession by the seller that they were only seeking the return of the interest payments. So it returns to the same outcome, but only because of that concession. Otherwise, it would have reached a very different outcome, one that would be far less favourable to my clients.
So logically, one might think the best starting point is to consider the construction of a contract, and and in particular the question whether the consideration is severable or non-severable.
Yes, well, I said that in order to deal with both, you have to consider the contract, and it may make sense, rather than dealing then with the principles of restitution, to deal with the contract first, and then we can return to those principles, which I do say have some application, particularly in a case like Mason and Chloe, for understanding what the contract says, but I'll come to that in due course. So if we turn then to the contract, which is at page 524, there are a number of copies, but this seems to be the most legible copy. And there were two contracts in materially identical terms, save for provisions as to the price in relation to shop 10 and shop 11. And the operative clauses, which we're concerned, are at page 525. And so you have the price at clause 3, which is said to be, it said that the total purchase price of the strata lot will be the sum of $120,000. Purchase price should be paid to the vendor as follows. On execution and exchange, $3,000 of deposit. The balance, being the sum of $117,000, should be paid over 20 years with interest at the rate of 12% per annum on the first day of each month. And so there is a distinction made in clause 3, I accept, between the purchase price identified and the interest payment. But ultimately, the interest, I say, works effectively as an accretion to the amount required to secure title, because in clause 4, it said that closing shall take place on payment of the final instalment due on the purchase price and all interest thereon. And so my client had to pay both in order to secure title. And then the key clause as regards possession is clause 5, which states that vacant possession of the strata lot shall be given by the vendor to the purchaser on closing. Now, pausing there, that in my submission establishes very clearly that there is no right to possession under this contract. It's clear that it's on closing that you get possession. And then there is a caveat to that, to say unless the vendor gives its express consent in writing to earlier possession and subject to such terms as shall then be agreed.
It does slightly stretch credulity to think that your client was buying a property which was a commercial property which he wanted to use presumably for a business on this instalment basis with no right to go in and occupy it for 20 years.
Well, there's a distinction between whether he had a right to occupy and whether he had an expectation. Certainly he had a very firm expectation that he would go in and occupy. And indeed, one of the functions of this clause would be to provide him with a very good incentive to pay off the purchase price earlier. Because what he wants to do is pay as quickly as possible.
Excuse me, but the access to the property didn't depend upon payment of the purchase price. In practice, the expectation that you're describing wasn't dependent upon paying the full price.
Well, no, he expects that there's going to be some agreement under clause 5. So his full expectation would be that it's going to be possible to agree terms by which he gets access to the property earlier. But quite what those terms will be are not set out. So, for example, it would have been quite possible for the seller to request a rental payment if, for example, the properties went up in value or for whatever reason that he wanted. He could demand a rent. As actually happened, he could insist upon payment of the strata fees. So I quite accept it is quite unlikely that he would agree to a situation where he'd never get possession, but ultimately it is in the vendor's gift to decide whether or not he will get that possession. And what he couldn't do is if the vendor said, well, I want you to pay me a rent for this property, and my client said no, he couldn't then say, well, I'm going to rescind the contract because consideration's totally failed or because there's been some breach. He'd be stuck with the terms to which he's agreed.
Mr. Watson, could I ask you about the basis of the calculation of the interest? Now, am I right in thinking that interest was payable on the basis that this would amount to compensation to the seller for the deferral of his receipt of the price over a period of 20 years?
Yes, I think I have to accept that is one of the consequences of it.
So at the end of the day, he would get the full price. Yeah, even though he would have remained in possession of the property on your case for the whole of the period.
In theory, that's possible. It's as I say, unlikely that would come about because the parties would quite clearly want to come to some agreement in order to be able to get possession of the property earlier. I fully accept that. But when one looks at the terms of clause 5, he has no right to be able to compel possession. He's not paying for possession. He's simply hoping that it's going to be agreed.
But if the seller has no more than a hope, how is it that if the buyer has no more than a hope, how is it that in neither of these cases did the seller demand a rent? And possession seems to have happened automatically the moment these premises were completed, without anything further being put in writing by either side. And there even ended up a dispute about whether there was a liability to make strata payments. But even though that was left apparently unresolved on one side's case, on any view, nobody suggested there should be any rent paid.
No, as it transpired, nobody did.
And was that just a sort of curious bit of beneficence on the part of the seller?
Well, there was no investigation as to what was said. There was clearly an agreement as to how strata fees were to be dealt with. And what happened, in fact, was my client paid the strata fees up until 2010. And thereafter there arose a dispute and it was ultimately conceded at trial. I fully accept that we were liable and on a contractual basis to pay those strata fees. So I quite accept that when the parties enter into this contract, they probably both have in mind that there will be an agreement as to possession, whether that means that there would be agreement as to possession on a rent-free basis, whether it would mean that one party would cover the strata fees, whether it means that there would be a split or an agreement as to how the property is insured. That's not spelt out in the contract. So it's certainly not my case that these parties actually entered into it subjectively intending that my clients would never get possession of the property.
But I mean, the effect of the instalment payment arrangement, as I see it, was that for every instalment of capital that was actually paid ahead of the end of the 20 years, the seller had the use of that money. And indeed, you have never claimed interest on the return of the capital payments. And for every instalment of capital that had yet to be paid, the seller would receive interest to compensate for not having the use of that money. So he would have, effectively under that arrangement, a commercial or economic full payment or crediting of the use value of the whole of the purchase price from day one, or at any rate from the date when interest started to run, which I think in practice was the date the premises were completed and ready for occupation.
Yes, I think that's right. But it's absolutely right that interest resulted in the seller having effectively the purchase price kept at the same level, because it gets, as you said, the use of money paid
and interest on the money not paid.
Interest reflecting the use value of that money. But
and yet you say it's perfectly possible for the seller to have said, and what's more, I will rent as well.
Well, he's perfectly entitled. When one looks at the terms of Clause 5, unless one says that the first part of that clause is to be rewritten, it states that vacant possession is to be given on closing, unless there is express consent in writing to earlier possession, subject to such terms as shall be agreed. So, what one would have to do is, in my submission, rewrite that provision in order to say that vacant possession shall be given earlier, shall be given earlier, and make some provision as to what the parties have agreed, as to which there was certainly no finding by the Grand Court as to.
I think it follows on your approach that the seller is contractually entitled to the value, use value of the premises twice over, in that he can have the value, can have the use of the financial value of the premises in the form of the instalments plus interest on the outstanding price. And he also is entitled to the possession or rental value of the premises as well. I suppose you would have to argue that if that's what the contract says, so be it. It just means that your client made a rather bad bargain.
Yes, he made a bargain that, on its face, is not very favourable to him. Subject, of course, to his firm expectation that he would be able to reach an agreement, because he might well say, well, if I pay the strata fees, there's often an appeal to having tenants in situ. It enables him to pay off the instalments and the interest. So there are reasons why he would be able to bargain for the possession that he in fact got, including payment of the strata fees. But where I would draw the lines, I would say that it was an expectation rather than contractual entitlement. And insofar as it was a bad bargain, of course this contract is on the seller's terms, it's one that he freely entered into, expecting that he would be able to negotiate possession.
Are we to take it that when your client went into possession, he was simply there precariously because there was no written agreement about the terms, or that from then on there must be understood to have been some bargain about possession being strata fee based but otherwise rent-free?
Yes, I think there has to have been some form of contractual bargain,
Yes.
probably in the form of a license rather than anything, a contractual license rather than anything else.
But not one that could be just terminated at will by the seller.
Well, there was no finding as to what was agreed between the parties as to termination. Certainly, when this agreement was terminated, before the Grand Court, the Respondent's argument was that both agreements were terminated. And indeed, it was said that there was a breach of the oral agreement by not having paid the strata fees. So
And I wonder if what we have to construe is a sort of combined bargain consisting of this written contract and the agreement which one almost has to infer took place when the buyer was let into possession,
well,
rent-free.
yes, I would say clearly you do have to construe that there were two agreements, and whether or not one describes that as a combined agreement or not. I say that there are two agreements which have separate consideration, separate basis.
Together, if you put them together, they make commercial sense. But if you keep them apart, they both make commercial nonsense, don't they? Because the sale contract appears, on one view, to be a bit of a nonsense in giving the seller the use of the value of the property twice over for 20 years. But equally, the possession agreement under which you get the use of a valuable property for 20 years merely by paying the strata fees is equally uncommercial.
Well, yes,
if you look at it on its own, rather than as part and parcel of a bargain that also includes this agreement.
yes, but where I would draw the line on that is I wouldn't say that I wouldn't accept that the interest payments were in any way to try and secure possession. They were, in my submission, directed at securing title and attempting to apportion the interest as being in some way in order to secure possession. Doesn't reflect any term of this agreement, but it also doesn't reflect the fact that if, for whatever reason, possession wasn't agreed, the interest would still be payable.
May I ask this question? I think a moment ago you indicated that there were two agreements. There must have been two agreements. There's no suggestion, is there, that a later agreement was reached other than the agreement which we see embodied in the document that you've shown us, together with any parallel agreement relating to possession. There was no suggestion that agreements were entered into on separate occasions.
No, the date for the agreement, the date for the oral agreement in relation to payment of strata fees, I'll check, but my understanding is it wasn't identified in the Grand Court's judgment. One has to assume that it was around the same time. Whether it was exactly coterminous, I don't know. I don't want to give evidence. But certainly I accept that these two bargains are clearly related.
May I ask then, if there were two agreements related, as you say, and entered into at about the same time, what was the consideration for the second one?
Well, the consideration for the occupation is the payment of the strata fees.
Right.
Whether one says that there was then further consideration is the matter that's in dispute, but certainly it was accepted, indeed it was part of the respondent's pleaded case that the consideration for part of the consideration for the occupation was the strata fees.
But the strata fees are already payable under the sale agreement.
No.
Oh, I'm sorry.
So, I'm sorry, I didn't hear you.
It's okay.
No. The insurance was payable by the seller under the agreement, but the strata fees weren't, and so there was some agreement. All the Grand Court recorded was that there had been an agreement that we would pay the strata fees. One infers, given that it was a pleaded case that it was consideration for the occupation, that was on a contractual basis. It's hard to see what other basis there would be for that. It was a matter that was agreed between the parties, so it was part of the oral agreement rather than the written agreement.
If we look at clause 2 of the agreement on page 525, it narrates that the vendor has supplied to the purchaser a copy of the proposed bylaws of the proposed strata corporation, and the purchaser has been informed and understands the proposed bylaws or a reasonable modification thereof, and shall affect the strata lot when completed, and the proprietor thereof for the time being. So it seems that the purchaser had notice of what was likely to be coming in terms of strata fees.
Yes, well, if he's seen the bylaws of the strata corporation, then he would have some understanding that strata fees would be payable. Whether those are payable by the licensee of the property or whether they're payable by the owner, of course, would depend on the particular bylaws.
Yeah, but it may give some guidance as to the parties' expectations. Yes, I see that. Thank you.
Well, it would be, I think, probably not giving evidence to say it would be fairly common for an occupier of a property to pay the strata fees in much the same way as one pays service charge in England.
Well, it's the same sort of thing, isn't it?
It is.
Yes.
It is. That's my simplistic understanding, but I think for these purposes it's
Well, I'd share that simplistic understanding. Thank you.
So that, I say, is clause 5, which I think where I get to is I accept that there is plainly an expectation of occupation, and I accept that there is an oral agreement entered into around the same time. But when one comes to look at and construe the contract, I say it is very difficult to apportion the interest as being paid on the basis or in consideration of the occupation, because they are not related. As the Court of Appeal identified, there are a number of differences between interest, which is fixed as a function of prevailing interest rates, and the outstanding amount of principal, and means that one pays a higher amount at the start and then progressively less as one goes on, versus occupation rate, which is fixed by reference to the value of the property. So there's nothing in the contract, I say, which apportions the interest as being somehow consideration for payment. Obviously, that is subject to the point my learned friend makes about the law in Victoria and how, as a matter of Victorian, possibly Australian law, instalment contracts do apportion interest as being occupation rent. But I say when one reads clauses 3 to 5, one can't find a justification for apportioning the interest to occupation.
There's no suggestion, is there, that the Victorian approach is statutory in any sense? It's just their attempt to apply common law principles of construction to the relevant bargains, presumably.
Yes, it's difficult because it's based on a number of authorities that don't all speak with one voice, that largely deal with relief and forfeiture cases, which plainly apply very different principles to unjust enrichment. And in none of the cases cited in the Mart passage that my friend relies on, as I'll show you, was interest ever claimed. So actually, what the authors of Mart are getting at is saying, in response to the argument that consideration will not have totally failed because a party's been let into occupation, they say no, in relation to the principle, it still has failed, and here are the authorities which support that. There aren't, to my knowledge, any Victorian authorities, or indeed other authorities, which say that where a party sought interest to be recovered and was told that they couldn't have it. But I'll show you those authorities in a moment. Okay. Before I leave the contract, can I deal with clause 6, which is plainly a clause that we place some considerable reliance on because we say it allocates the risk on default. And clause 6 on page 525 says that if the purchaser fails to complete this agreement at the times and as provided for in paragraph 3 hereof, the vendor may at its option rescind this agreement by written notice to the purchaser. And there was a considerable debate, which is not before your lordships, but there was considerable debate in the Grand Court and in the Court of Appeal as to whether or not clause 6 applied. And both the Grand Court and the Court of Appeal agreed that the effect of the termination of the contract was to invoke clause 6, or that clause 6 applied. And so what clause 6 permits is that the vendor, having rescinded the agreement, can forfeit and keep absolutely as liquidated damages the deposit hereof and all interest accrued hereon, and may in addition keep absolutely out of any further sum paid by the purchaser such amount as is sufficient to compensate for any work done to the strata lot by the vendor at the request of the purchaser, which involves a deviation from or amendment to the basic plan for the strata lots, or any substitution requested by the purchaser in respect to the fixtures and fittings installed in the strata lot. So pausing there before one gets to the carve-out provisions, what the clause permits is that if there is a breach and a failure to complete, the deposit is forfeited, as is interest on the deposit. And so there has been some consideration to at least interest on the deposit. But then out of any further sum paid, an amount sufficient to compensate the vendor for work done essentially that deviates from the plan. And I say that the provision saying that it may keep absolutely out of any further sum paid by the purchaser identifies what it is that they are entitled to keep out of what was paid, because it must follow that out of any further sum paid, and specifying what may be kept, it must follow that we are entitled to the remainder back in my submission, because otherwise it's not really clear what the clause is doing. And if that's right, and that, as I'll come to, is a similar conclusion to that which was reached in Mason and Clouet, means that as a result of clause 6, we would be entitled to our money back as a result of the parties' express allocation of risk of failure to complete the contract. Now, it might be said that, and indeed it is said, that results in a rather large payment when one gets towards the end of the contract. And I say that has two answers. The first is that the vendor at the end of the contract is entitled to keep and resell the property And so he can, if the property has increased in value, he gets to keep the uplift and gets to keep the benefit of that. But second, this is, of course, a clause that is optional. So if he considers actually the consequence of clause 6 would not be very favourable to me, I would be better off insisting on performance, he's perfectly able to do that. He doesn't have to terminate. And as we saw here, he can quite easily have got everything that he was due under the contract by insisting on performance. So the decision to invoke the restitutionary jurisdiction and to have to pay back the monies paid over is one that is at the vendor's option, I say. So it doesn't have the stark injustice that the Court of Appeal seem to see in this, because to see an injustice, I say, overlooks the fact that the vendor is perfectly entitled to insist on continued performance. And if he does that, he'll be entitled to pursue and claim the outstanding purchase price, but the consequence of that is he won't get to keep the property.
I note that in clause 7 that the agreement is subject to conditions, covenants and provisions set forth in the schedule.
Yes.
And the schedule on page 527 says that the purchaser agrees to take title of the strata unit subject to certain things, including the bylaws. And the covenants in bylaw 3, for example, are deemed to be incorporated into the agreement. Were the bylaws before the courts below, or did they contain nothing of relevance? I just wondered if they might give some clue as to the expectations of the parties.
No, my understanding is they weren't before the court. I don't think I've seen them. I'll be corrected on that if I'm wrong, but it would be again fairly common in an agreement to purchase a lot. If one uses the analogy of purchasing property in a commercial office property subject to a long lease, it would be very common to have a provision in a schedule which requires observation of the tenant covenants under that lease. And so, as I understand it, that's what that is doing. But I don't think any point was taken on the bylaws.
There can be no doubt that the bylaws must contain some obligation to pay strata fees, but the trouble is we don't know whether that was on the owner or the occupier.
No.
Thank you.
I'm told that strata fees are always payable by the owner. I mean, it stands to reason that ordinarily the owner, rather than simply a licensee, would have to pay them, subject to any terms of the license requiring reimbursements. And indeed, if one goes back to my analogy of where a sublease is granted or a sublicense is granted, ordinarily what one does is, as the occupier, passes the service charge up the chain rather than necessarily paying it directly.
Yes, one would have thought that if the bylaws had said in terms that the occupier was to pay the strata fees, that then the ability of your client to dispute his liability for the strata fees might have been limited.
So, stepping back from the contractual provisions, I say that one has a clear framework allocating the risk of non-performance in clause 6. And so that quite apart from whether one analyses the consideration for the interest as being in some way linked to possession, I say that when one looks at the terms of clause 6, it fairly clearly allocates the risk of precisely what happened and sets out the consequences. And I say that it is a consequence of clause 6 that we would be entitled to our money back, whether one analyses that as a contractual right of repayment or as identifying what the basis would be and the restitutionary consequences. I don't think matters hugely. Now, the complication, of course, in clause 6 is that there is the provision which says, and no further rights of action shall arise in respect thereof, nor shall any party hereto have any further rights, demands, actions, claims, damages, one against the other, which I say was one of the difficulties with the Court of Appeal's analysis for a restitutionary credit for mean profits. But that provision, I say, can't prohibit the return of the sums paid, because otherwise it would render somewhat meaningless the earlier wording to say that the vendor may in addition keep absolutely out of any further sum paid by the purchaser, which must assume that there's going to be some repayment. What the later wording is directed at is saying that effectively clause 6 is where you look to for the consequences of a failure to perform and termination, and you can't bring a claim for damages for loss of bargain or anything of that nature. And so if I'm right on that, that is, I would say, it deals with the Respondent's case on the return of the interest, or the dealing with it as occupation rent, because even if one clarifies it as occupation rent, they're still not entitled to it back. They're still not entitled to keep it under clause 6. And it also, I say, is a fatal flaw in the Court of Appeal solution, because this clause allocates the risk, and there's no scope for what the Court of Appeal did, which was effectively to provide a form of counter restitution in respect of mean profits, or allocation of the price to possession effectively only, again by reference to mean profits in some way. If I can turn then to a couple of the authorities, which, first of all, the authority Mason and Clue in relation to the contract, and where I say it supports the fact I'm entitled to the monies back under clause 6, and then to deal with some of the Australian authorities.
Well, it supports the proposition that you're entitled to the return of payments for which you receive no consideration.
Yes. But
The issue, the core issue probably, I think here is one I mentioned earlier, is whether on a proper construction of the agreement, insofar as we have it in front of us. The interest payments are part of the consideration of the sale, or are consideration for a grant of possession, which is not expressly referred to in this document.
yes, well, I said there are two stages in the construction, because once your lordships have construed that question, you need to then ask what is it that clause 6 provides or requires is clause 6 saying, when it says that the vendor may keep out of any further sum paid, does that mean may keep out of any further sum paid, and that's it, or may keep out of any further sum paid, and also may keep any sums for which consideration or basis has not totally failed? Is there an implied limit on the amount that needs to be repaid by reference to the law of unjust enrichment?
One ought really against the background of common law cases such as Mason and Clue, to the effect that if you have not received consideration for a payment, you're entitled to a return on the acceptance of repudiation. But if you have received even partial consideration, then it's not returnable.
Well, I would say no, because what clause 6 is doing is it's allocating risk. So it's saying that it's identifying what the vendor is entitled to keep, and so the vendor is entitled to keep 4 things. It's entitled to keep the deposit. It's entitled to keep interest on the deposit. It can keep any sum sufficient to compensate it compensate it for changes to the effectively the specifications, and may keep the property and the proceeds of sale. I say that clause 6 therefore delimits what they're entitled to keep, and it follows that anything else is a sum that they're not entitled to keep and they have to hand back.
So clause 6 is the effect of clause 6 is that the buyer is entitled to the restitution even of payments for which the buyer has received full consideration.
Well, yes, or it could be said that it helps to identify what the consideration was, because in identifying that there is... One way of looking at it is you say you're simply entitled to anything back irrespective of questions of restitution, whether it's you have to identify the unjust factor and apply the banque financière criteria. Another way of looking at it would be to say it helps one to identify whether consideration has totally failed, because it expressly identifies the sums that need to be kept, and so it would follow as a matter of construction or a matter of analysis based on the contract that consideration in relation to the other payments would have totally failed. So you can analyse it both ways.
I mean, clause 6 actually thinks in terms about the interest which is accrued on the deposit in the hands of the seller.
Yes.
Why aren't you, on that strict analysis, claiming back interest on the instalments actually paid?
It's a good question.
It's a serious question.
It's one that we didn't seek in the Grand Court. I didn't appear in the Grand Court.
So you're the victim of a procedural piece of history. Because the logic of your submissions is that you'd be entitled to that as well. Not
necessarily. I would say potentially yes, albeit that if we're entitled to keep out of any further sum paid, what it identifies in clause 6 is that we can get back what we paid. Whether one says that we're entitled to interest on that sum as well would be not necessarily a question of construction of the agreement, but a question of the law of unjust enrichment. But I quite accept the logic of what I'm saying is that I would be entitled to interest back, but it is not something that we have claimed. It's not something that was claimed in the Grand Court, and so... if I can turn then to Mason and Clue, which appears at page 1525 of the electronic bundle. And one can see from the head note that this was a case involving an instalment contract. It provided that a deposit should be paid immediately and 2 instalments of cash would be paid at certain dates, and then the balance would be paid within 10 days of the production of a certificate that certain buildings upon the land were completed, and that if the purchaser failed to comply with the conditions of the contract, it might be forfeit and the land resold, and the purchaser did fail to pay the balance of the price, and therefore the vendor rescinded the contract, and it was held when the purchaser sought the return of the instalments that he was entitled to those instalments back. And the judgment of the board was delivered by Lord Dunedin. If one goes to page 1527, he sets out the terms of the contract, and towards the bottom of the page, I think 10 lines up, you can see that he sets out clause 3 of the contract. It says that in the event of either of the 2 instalments of 10% above not being paid by the purchaser, here stated the vendor shall be at liberty to cancel this agreement, and all money paid to them under this agreement shall forthwith become forfeit, and for purpose time shall be deemed to be of the essence of the contract. In case the purchaser shall make default in completing his purchase when the municipal certificate has been issued as aforesaid, he shall pay to the vendors interest of the balance then owing at a rate of 12%. And then clause 13, if the purchaser shall neglect, or this is over page at 1528, if the purchaser shall neglect or fail to comply with the above conditions, his deposit may be treated as forfeited, and the defender shall be at liberty with or without notice, and notwithstanding any pending negotiation, proceeding or litigation, to resell the property either by public auction or private contract at such time and under such conditions as may deem proper, and any such resale or attempted resale and any deficiency in the price obtained on a resale shall immediately thereafter be made good and paid to the vendor by the purchaser and should be recoverable by the vendor as liquidated damages. So it is a slightly different clause to the one that we're concerned with. But the analysis is instructive. If one goes to page 1530, 11 lines down, when he's considering the termination, he says the law is quite plain. If one party to a contract commits a breach, then if that breach is something that goes to the root of the contract, the other party has the option. He may still treat the contract as existing and sue for specific performance, or he may elect to hold the contract at an end, i.e. no longer binding on him while retaining the right to sue for damages in respect of the breach committed. And I, as your lordships know, rely quite heavily on the fact that the vendor could have sought here not to rescind the contract. And then the next paragraph, he says, there remains, however, the question decided by the learned Chief Justice as to whether the instalments can be recovered, and various authorities were quoted to their lordships. Their lordships think that the solution of a question of this sort must always depend on the terms of the particular contract. And I say that is absolutely right, that when one looks to whether or not you can get your money back, your first port of call has to be to look at the terms of the agreement. In relation to this agreement, at page 1532, the second paragraph, he says, they therefore turn to the contract. This specially distinguishes in terms between deposit and instalments. It then specially deals with, in clause 13 with what is to happen if the purchaser is in default. The deposit is forfeited, and that is all. It would seem to their lordships quite clear that the instalments are not to be forfeited. The truth is that the defendant's contention really amounts to a claim to keep the instalments as liquidated damages for the breach of contract for which they are entitled to sue. This was the proceeding unsuccessfully attempted in the case of Harrison and Holland. So while it's a different type of clause, the fact that the point being made is that if a clause provides that certain amounts are to be forfeited, one starting point is that the remainder is paid back. And I say that is, whether one analyses it as a short point of construction or a question of unjust enrichment, doesn't really matter. That is the case here. Clause 6 provides for what's supposed to be forfeited. It has given consideration to what the vendor is entitled to keep. and it doesn't provide that they're entitled to keep either interest, reflecting the value of possession, or mean profits. And indeed, it's rather hard to say, and if I'd say that if the parties had intended that it would be the interest would be forfeited in some way, then they could quite easily have provided for it, quite easily have put that in the contract, and then there would be no difficulty. In the case certainly wouldn't be before your lordships. Now, my learned friend's analysis starts from a different point. He relies very heavily on the law of Victoria, as he says it stands, which he says does distinguish between principal and interest. And you can, he relies on the extract from Mart, which I understand began life as the sale of land in Victoria and is now the sale of land in the whole of Australia. So it's now more extensive in terms of its territorial scope. And the passage he relies on is at 1280, page 1245.
Sorry, 1245.
1245, yes. So you can see that it's dealing with the right to recover instalments in the absence of an express provision for forfeiture. Now, of course, quite how that interacts with an express allocation or an express clause dealing with this forfeiture of part of the payments is unclear. But it says, where the vendor elects to rescind the contract upon the ground of purchaser default, what is the position of the parties as to instalments of principal monies paid by the purchaser if the contract does not provide for forfeiture thereof to the vendor? If the purchaser has not been in possession of the property, there is a clear entitlement of common law to recover those instalments from the vendor. Is the position any different if he or she has had possession under the terms of the contract? And so that goes back to the first issue of construction that we were dealing with earlier, whether or not, in fact, my client had possession under the terms of the contract or under a separate agreement. It says, notwithstanding earlier doubts, it now appears to be settled law that where the purchaser has been in possession, he or she is still entitled, upon the adjustment of rights with the vendor, to be credited with instalments of principal paid, but not with the interest already paid. And it cites a number of authorities in footnote 2 in support of that proposition. Now, MacDonald and Denny's Lascelles is not before your lordships, and that's because it made no mention of interest at all. Berry and Mahoney was a relief from forfeiture case where the purchaser sought the return of payments made, and therefore it was held. It wasn't clear that he actually wanted whether the interest was actually sought, but certainly it was applying different considerations because the question of relief from forfeiture relies on a far more wide-ranging, equitable jurisdiction rather than the principles of unjust enrichment that we're dealing with here. And so it's not tremendously helpful in coming to the conclusion that interest would be would not be repayable because it's effectively a form of occupation rent.
Well, but a relief from forfeiture case has to start with an examination of position of common law before you see what effective relief you can get from its validity.
Yes, I accept that.
I might find some help in the analysis, as it were, at the preliminary stage.
Well, the problem is that in Berry and Mahoney you have an express forfeiture clause, and then the relief from forfeiture. Relief from forfeiture is normally not looking at common law relief from common law lack of restitution.
So what's all the instalments for forfeiture?
Yes. Real estate securities and Q golf links. Again, it's not before your lordship, and that's because interest was conceded. It wasn't sought. It wasn't the return of the interest wasn't sought in that case. It doesn't. The matter wasn't argued in any sense. Mallet and Jones is in the bundle, but the return of the interest wasn't sought. So I accept it may have proceeded on an understanding that the law of Victoria doesn't allow the recovery of interest, but it's not terribly helpful for your lordships in understanding the principles, because it was based on a concession.
Did the court not comment on it?
No, it simply said it's ordinary principles. I can show you lordships the authority. It's at page 1511.
Is that Mallet and Jones?
Yes, Mallet and Jones.
Sorry, the page again?
The authority begins at page 1511.
Thank you.
And the decision of Justices Dean and Smith of the majority is at 1512. You can see down at the bottom of the page the final bullet point sets out the terms of the contract and notes that pursuant to the contract the respondents went into possession on the 7th of April 1956.
Unfortunately, the way that it's printed, we can't identify the passage which is cited in the Zumar textbook.
No, we can see if we can find a better copy of that authority. It was something I had some trouble with, but it doesn't appear. Because what you can see is, if we go through the authority, the bulk of the discussion concerned the question of damages for fraudulent misrepresentation. You can see it at the bottom of 1512 running over to 1513. In the action, respondents complained that they had been induced to enter into the contract by the fraudulent representation of the defendant Mallet as agent for the vendor. And so they sought damages and also the return of payments made under the contract. And one can see that one can see the findings in the last two bullet points before one gets to A, B, C and D. At the hearing, the respondents claim to recover instalments paid under the contract and return of the deposit on the facts then existing. Claim for adjudication were by the respondents rescission or alternatively damages or the return of the deposit, return of the instalments paid, 136.
It may be, and I'm just trying to help you, it may be the passage cited, at least one seems to be material, is on our page 1520.
Yes, I think it is, but it's important. I say that what they're doing at 1520 is construing the provisions that are at 1519. Because at 1519 at the top, it says the contract is in the common form and is extremely confusing despite its august sponsors. It incorporates the 1956 copyright conditions of sale, which I have to say are very, very difficult to track down, having gone through now a number of amendments. But you can see that they say that set out the contract so far as they say is relevant, by stating that it seems to us, therefore, the rights of the vendor are governed by Table A, except insofar as expressly affected by the copyright conditions. Clause 6.2 of Table A is not affected in any way by the copyright conditions. The appropriate notice have been given in accordance with Clause 6. Provisions of Clause 6.2 applied. As far as relevant, these are: the contract shall thereupon become rescinded and deposit shall be forfeited to the vendor. Vendor may proceed to take or recover possession of land sold. Vendor may, at his option, retain the land and sue the purchaser for damages for breach of contract. Pending the determination of such damages, the vendor shall be entitled to retain all instalments paid hereunder, or resell the said land, either by public auction or private contract, and any deficiency in the price upon such resale and the expenses thereof shall be paid upon demand to the vendor as and by way of liquidated damages. And then in clause 7, it says if the vendor exercises his right of resale given to him by condition 4 or condition 6.2 hereof, he should be entitled to apply any instalments of purchase money paid to him in satisfaction or partial satisfaction of any deficiency, and in exercising any of the said rights of resale, it shall not be necessary for the vendor to first tender a transfer to the purchaser. And then they go on to analyse that by noting that the rights of the parties fall to be determined in accordance with the clauses quoted. They contain no provision for forfeiture of the instalments paid. Respondents do not contend the right of the vendor to forfeit the deposit as a penalty. Accordingly, no relief is sought on equitable grounds in respect either of the deposits or the instalments. It's clear enough that the respondents are entitled to recover back the instalments of principal they've paid, less than the items expressly made payable thereout. They've paid out £162, 10 shillings in all, but it is agreed that the sum of £70, 14 shillings 6 represents interest actually paid by the respondents as part of their weekly payments, and such amount is not instalments of purchase money within the meaning of Clause 7. So it was agreed that in relation to Clause 7, which entitles the application of instalments of purchase money to make good a deficiency, interest didn't constitute instalments of purchase money, and therefore it wasn't to be used in Clause 7. And then we come to the question of, on page 1520, where they deal with the question of an occupation rent. Appellant McElroy contends that he is entitled to charge an occupation rent in respect of the respondent's occupation, and that in calculating the deficiency in price, no order should be made until it is seen whether Mrs. Staines carried out her contract. In our opinion, Appellant McElroy is not entitled to occupation rent. In any case, he cannot have both an occupation rent and interest, and we think he's entitled to retain the interest receives. In cases where the contract provides for forfeiture of instalments and the purchaser seeks relief in equity against such forfeiture, it's common to allow relief on terms which include rent in such cases, but whereas here no relief against forfeiture provided by the contract is sought, the matter must depend on the terms of the contract. The contract contemplates that the instalments will be repaid to the purchaser, less the items specifically referred to, and impliedly negatives any further deductions from the instalments of the purchase money. So it's really rather far away from the cases that we're dealing with, save that it emphasises that the primary question is to look at what the contractual provisions in fact provide. What it's not doing is expressing any general principle in relation to the law of unjust enrichment. Indeed, it's far from clear that the law of unjust enrichment was it wasn't a concept known very well to English law at that time, and it's far from clear it's a concept known to the law of the state of Victoria at that time. And it's not expressing any more general principle, I say, than what recovery was allowed under the terms of the particular contract they were dealing with. If one then turns back to the Mart extract at page 1246, the final two authorities which are cited are English cases of Dees and of Stockloser, and neither of those cases concerned interest payments. Stockloser was a question of relief from forfeiture. So it doesn't, in my submission, really provide, this passage thus far doesn't, in my submission, provide any real support for the suggestion that, in general, interest is to be treated as akin to consideration for the occupation. What one has to do is consider the terms of the particular contract involved, construe those in Lim 1, the two-stage construction I was discussing with Lord Reid, that there is Lim of Construction 1 where you ask what's the consideration for the payment, and then Lim of Construction 2 is to construe the party's allocation of risk in Clause 6, and what does that entitle. And then the remainder of the passage discusses a view set out academically in the Australian Law Journal, effectively to the effect that you can't recover anything at all if you've had possession under the contract because consideration has not totally failed. One can see that 12 lines from the bottom, saying, in substance, this contention is that a contract for sale on terms, the purchaser being entitled to possession before paying the whole of the purchase money, is an entire contract for use and occupation for a specified period, and a transfer of the freehold at the end of that period in return for the principal sum with interest thereon. And they say, 3 lines further down, it's submitted, however, that the consideration is not entire but divisible, and that a contract such as we are considering is, from the point of view of failure of consideration, properly regarded as a main contract for the transfer of the freehold in return for the principal sum, and a subsidiary contract under which the purchaser is entitled to possession pending execution of the transfer in consideration of the payment of interest on the balance of the purchase money from time to time unpaid. And of course that simply begs the question.
That takes us back to the real estate in Kew Court in this case.
Yes, which
According to notes.
yes, which didn't deal with interest.
You say it doesn't.
Yes. The problem is that the entire passage rather begs the question, when it's talking about a contract such as we are considering, it really begs the question as to what are the terms of the particular contract. And my submission, it's not terribly helpful to look at broad statements of contractual principle. What you have to do is look at the particular contract itself and construe it, applying the ordinary principles, and ask yourself, well, what is the basis for which these payments were made, and what is the allocation of risk?
Before we leave this, do you need any help from Cayman and Stanley Estates, which is the one referred to in note 4? Again, I have horrible suspicion of it's anything but interest.
I don't believe it does. My recollection is
I
it.
haven't looked.
Yes.
It's just I'm looking at a passage for which it's said to be authority.
Well, the problem, what the passage says, the consideration of payment of instalments of principal has wholly failed, and the purchaser is thus entitled to recover them common law as money hadn't received as to his and her use. My recollection is it doesn't. That none of these cases actually, it's not in the bundle. It's not one relied on by the respondents, and none of these cases contain the kind of detailed discussion that one would hope to see in relation to interest as occupation rent. And in any event, there is, to my knowledge, no authority outside of the Victorian authorities that have been cited, which are some time ago applying this proposition that the interest is severable, and certainly it doesn't appear to have been adopted or picked up in any sense in English law. Now, I fully accept to some degree that would be because instalment contracts appear to be more common in Australia than they are in England.
We have applying Cayman law, which might, insofar as Cayman's comparable families, take inspiration as much from Australia as from
Of course, and it's said by my learned friend that because there is a torrent system of registration, that one might want to look more closely at the Australian position rather than the English position. It's not entirely clear to me why the system of registration would make any difference at all to the question of unjust enrichment, because it's rather just saying, well, because there's a similarity in one respect in property law, you therefore should adopt an entirely different one. It doesn't seem to me to really get one anywhere. Well,
Torrens point might, I don't know if it does or not, go a little way to explain why what in England in this case would probably be done by a repayment mortgage is done by a postponed conveyance of title, because the instalment structure is absolutely the same as the repayment mortgage structure.
yes, say for, of course, one of the big differences, say for who gets ownership of the property.
Well, also the remedies for default,
Yes.
because that would lead to a sale with the seller being paid off out of the proceeds and the equity that was left going to the buyer.
Yes.
Yeah.
Whereas in this contract, the ownership remained with the vendor throughout, and in fact, the Grand Court judgment records that the vendor used his ownership in the currency of the contract, for example, by mortgaging the properties in 2009 in order to fund his strata development. So it is, the analogy with a repayment mortgage can only go so far, because of course the bank doesn't have any right to then, subject to its own.
No, I'm simply thinking that the different system of registration might have something to do with why they didn't go down the mortgage route, but I have no idea.
But the principal characteristic of the Torrens system is the conclusiveness of the register, as I understand it. But it's equally conclusive of the validity of a mortgage as it is the validity of ownership. So I'm not really sure how the Torrens system has any bearing on the question before us.
No, and it's certainly not clear to me. I don't want to spike my friend guns, because he clearly can develop the submission as he sees fit, but it doesn't seem to me to have any relevance, and I think there is a danger in drawing conclusions about the extent to which instalment contracts are or are not common in a particular jurisdiction, because of course that depends to a large degree about what one means by common, and why that would have any significance at all. It would only, in my submission, have significance if it had resulted in judicial determinations which bear on the questions which your lordships are asked to address, and there certainly doesn't appear to be any Cayman authority that any of us are aware of which bears on any of these questions. I do apologise. I've rather left my proposed order at the start, but I was proposing then, unless I can assist you any further on my own friend's alternative case, to turn in the time I have available to the Court of Appeals analysis, which...
But a new approach, I mean, it's Court of Appeals analysis is completely hopeless. Because on your approach, the contract has entitled you to the return of the interest as well as the capital instalments, and if you have a contractual entitlement to it, it can't possibly be unjust enrichment.
Yes.
End of story.
Yes, that's absolutely right. There are other flaws that I say with the Court of Appeals analysis, but the central flaw I say is that they didn't start with the starting point was to look at an analysis of some of the authorities on the law of restitution, and to conclude that there needed to be restitution in respect of or there needed to be some adjustment to the monies we got back as a result of our occupation, and then to ask themselves whether that was consistent with the contract. Whereas what one should do is to look at the contract first, construe that, and then ask oneself, is there a restitutionary remedy, and to what extent does it need to be adjusted? And my submission is that once one construes the contract properly, there's no need for the Court of Appeals analysis. And I've addressed it in some detail, the four fundamental errors that I say the Court of Appeal made in the written case. I noted it's inconsistent with the party's contract, paragraphs 93 to 98 of the written case, and that at best possession was a collateral benefit. It wasn't the benefit that was primarily bargained for, and that's at paragraphs 99 to 120 of the written case. And in relation to collateral benefits, it is, in my submission, well established that the fact that you have obtained a benefit as a result of your contract does not necessarily mean that that was the benefit for which you bargained. That doesn't mean it was the basis for your particular payment. What you have to do is look at the basis for the payments that were made, rather than asking oneself, well, what benefits did a party receive, and therefore making some kind of restitutionary credit. And I've cited a number of authorities in support of that proposition. The main one, or the clearest statement of that, is in the Rover and Cowan film case, which is at page 1544. In the speech of Lord Justice Carr, which at the bottom of G, it said the test is whether or not the party claiming total favour of consideration has in fact received any part of the benefit bargained for under the contract or purported contract. The relevant principles are set out in Chitty on contracts and the authorities there cited, to which we understand the judge was not referred. It is convenient to quote the following passages from the text, and it sets them out, and then over the page at C, it said the role of contractual specification means that it is not true to say that there can be a total failure of consideration only where the payer received no benefit at all in return for the payment. The concept of total failure of consideration can ignore real benefits received by the payer if they are not the benefit bargained for. And then it addresses the hire purchase cases, which I've cited. First, Rowland and Deval, which was cited very briefly by the Court of Appeal, noting that the plaintiff bought a car from the defendants and had the use of it for several months, but then discovered that the seller had no title, with the result that he had to surrender the car to the true owner, sued for the return of the price, on ground there being a total failure of consideration. The defendant denied this, pointing out that the plaintiff had use of the car for a substantial time. His contention succeeded at first instance, leaving the plaintiff with only claim for damages. This court unanimously upheld the plaintiff's claim. Consideration for which he bargained was lawful possession of the car and a good title to it, neither of which he got, although the car had been delivered to him pursuant to the contract and he had its use and enjoyment for a considerable time. There was a total failure of consideration because he had not got any part of what he bargained for. Now, just pausing there, my learned friend, I think, fairly observes that what had been bargained for in Rowland and Duval was lawful possession and ownership, and he hadn't, the purchaser hadn't got either, because the possession that he got was only possession as against the contractual counterparty rather than possession as against the world. But the point is, and the point that's made in more clearly in subsequent decision of Mr. Justice Finnemore in Warman and Southern Counties Car Finance Corporation, is that plainly the purchaser had received some benefit under the contract, in the sense that prior to the contract he didn't have the use of this car, and then he got the use of the car. So he didn't have everything that he bargained for, but he had certainly got something that could be said to have been a real benefit. But it said that plaintiff was buying a car on hire purchase when he became aware that the third party was claiming to be the true owner of the car. He nevertheless went on paying the remaining instalments and then the necessary nominal sum to exercise his option to purchase. When the true owner then claimed the car, he surrendered it and sued the finance company for the return of everything he paid. He succeeded on the ground of total failure of consideration. He'd not bargained for having use of the car without the option to purchase it. And then Lord Justice Carr goes on to dispose of the appeal in Rover, noting at 925A that the relevant bargain, at any rate for present purposes, was the opportunity to earn a substantial share of the gross receipts, pursuant to Clause 6 of the schedule, with a certainty of at least breaking even by recouping the advance. Due to the invalidity of the agreement, Rover got nothing of what they'd bargained for. There was clearly a total failure of consideration. Because in Rover, what had happened was Rover had received the films for dubbing and distribution in Italy, but wasn't going to receive the monies and the gross receipts that would be obtained from the film actually being watched by people, and so hadn't really got any benefit of the contract. So I accept that case on its facts is not tremendously helpful, but the analysis still stands that where one obtains a benefit, it's not simply enough to stop there and say, well, that's the end of the analysis for the purposes of restitution. You have to ask, is it the benefit that was actually bargained for? And here, as a matter of construction, as we were discussing earlier, I say the benefit that was bargained for was ownership rather than possession. The basis for which the interest was paid was in order to obtain title rather than to obtain possession. And the next difficulty with the Court of Appeal's analysis is that what the Court of Appeal was, or what the outcome the Court of Appeal came to was, in my submission, really a question of giving counter restitution rather than apportionment of consideration or applying any question of, it's described as accounting as a matter of restitution. I say it was simply counter restitution. And that's because paragraph 57 of the Court of Appeal's judgment, which appears at page 16, Justice Appeal Ricks was dealing with the submission that the sellers cannot claim damages for the buyer's default in the final few lines of Clause 6. But that's not, however, the issue for present purposes. The sellers do not have to claim anything by reference to the contract. It is the buyer who has to claim to recover his payments, and the question is the value of that claim in restitution. In any event, the sellers, on appeal, do not counterclaim for anything beyond what they've already been awarded, save for the interest payments, on the hypothesis that those would otherwise have been recoverable by the buyer. In my view, however, the accounting between the parties has to be done as a matter of the buyer's claim in restitution, not by way of a counterclaim by the sellers as damages for breach or as anything else. In the circumstances, I do not have to decide whether the contract ended as a result of common law acceptance of the buyer's repudiation entirely outside of Clause 6. That said, I agree with the judge. So it reads, it's a difficult passage to square with the requirements of a claim of unjust enrichment. There wasn't an attempt to apply or at least expressly apply the banque financière criteria or anything like that. It reads as though the Court of Appeal is saying it's an apportionment analysis, that effectively the consideration hasn't failed in respect of such amount as to give rise to such amount as reflects the value of the possession. But that can't be right, because the Court of Appeal's analysis isn't assessed by reference to interest or any payment made under the contract itself. It's assessed by reference to mean profits, which are entirely outside of the contract and will naturally fluctuate over time and will be entirely unknown to the parties at the time of entering into the contract. And equally, the statement in paragraph 63 that, but for the appellant's concession to limit their claim to the amount of the interest paid, the deduction would have been higher, means that, in fact, all of the payments that we made would have been, on this analysis, forfeited and attributable solely to possession. And that really can't be right as a matter of apportionment. It would mean that essentially my client wasn't really paying everything for possession and wasn't paying anything to obtain the valuable title, which really rather a difficult analysis. The easier analysis is instead to say that this is a matter of counter restitution, and there is a degree to which that's reflected in the judgment, because in paragraph 50 at page 15, in the last 3 lines, it said, "There is no reason why, in the pursuit of avoiding unjust enrichment on the part of the seller, the buyer should on his side be left unjustly enriched by his possession." So really what the Court of Appeal appears to be doing is saying, well, it's a case of counter restitution and set off, saying you've been unjustly enriched by your possession, and as a consequence we limit your restitutionary award. But that limitation can only apply really because it's said that the vendor has a claim in restitution against us, that it's entitled to then set off. The problem for that is that it's inconsistent with the terms of Clause 6, which provide that there be no further claims. It also suffers from the problem that there's no identified ground of restitution in respect of my client's occupation of the property, whether it's alleged to be failure of basis or some other, probably must be failure of basis, but it's not identified. And in fact, up until at least 2010, the basis for the occupation, in terms of payment of the strata fees, my client was fully up to date. So saying that the consideration had nonetheless totally failed is rather a difficult analysis, and it's certainly not one that the Court of Appeal set out in any detail. And most problematically, there was actually a claim for mean profits in respect of occupation pursued in the Grand Court. And at page 158 of the electronic bundle, I'm so sorry, page 138. It said that the defendant had originally pleaded as an alternative compensation from the plaintiff by means of mean profits for his occupation of each parcel from the date of him taking possession to the date of him vacating. At the close of the case, as clarified in the most helpful further amended schedule of loss and damages prepared by counsel for D, D made clear that he was no longer pursuing this alternative claim for an occupation rent.
But before we leave this bit of the Court of Appeal,
Yes.
at page 17, do you challenge the last sentence of paragraph 59 and then what is said in paragraph 60? I think you do.
I challenge that it must mean in all circumstances, gratuitous possession, yes. Because the assumption that's being said is the whole arrangement only makes sense, however, on the basis that the buyer takes possession. And what appears to be...
and the consequences in terms of how you construe clause 5 in paragraph 60.
Yes, well, the problem with the way that the Court of Appeal construes clause 5 is it reduces clause 5 effectively to nothing, because it says that clause 5, when clause 5 says expressly that vacant possession will be given on closing, except on such terms as should be agreed, effectively, nonetheless, the payments of interest or the payments being made are in some way to secure that possession. Now, and in paragraph 60, Justice Appeal Ricks notes that there are some problems with that, because he says the structure of the transaction makes it plain that possession by the buyer is intended. That said, first the development has to be completed before the buyer can be let into possession. Of course, there's no time frame on that. Secondly, there may be marginal matters to agree at the time for possession, such as regarding who will pay for strata fees or will insure. The characterisation of those as marginal matters certainly depends on whether or not they are easily capable of agreement. But of course, one can quite easily think of other matters that would need to be agreed. For example, the use that the properties might be put to, any questions of access. It's really something that the parties plainly intended or plainly envisaged that there would be an agreement reached, but the contractual framework itself doesn't provide for any right to possession, and the payments of interest were not to secure that possession. So I quite accept that there was, and I said earlier, I quite accept that it was envisaged there would be an agreement. But to say that the transaction only makes sense if on the basis that the buyer takes possession doesn't deal with what's going to happen to the marginal matters that Justice of Appeal Ricks identifies at paragraph 60. Because hypothetically, suppose the properties had, in fact, skyrocketed in value and the purchaser was making money hand over fist. In that circumstance, it might be quite understandable if the seller had come to the purchaser and said, actually, I'm going to start charging a rent for this occupation unless you pay off the property. Because in those circumstances, the value of the possession is far higher. Quite except on these facts, that didn't happen. And it was agreed that they'd enter into possession for simply payment of the strata fees. But that wasn't, I say, a function of the contract. That was simply the expectation of the parties. It doesn't affect the position as a matter of restitution. The final issue, and one that I've dealt with to some degree already is the objection taken by the Court of Appeal and also by the respondents in their alternative case that effectively my case is entitling my client to some form of windfall by means of uncompensated possession. And I say there are four difficulties with that objection. The first is to consider what would have actually happened had the contract been performed. Had the seller taken up the offer to sell the properties to a third party, or indeed had my client been somehow able to get his hands on an additional $30,000, that would have been everything that the seller would have been entitled to, plus obviously the strata fees. So it's not the case that so the party's bargain was that there wouldn't be any further compensation for possession or any further sum paid by my client other than those strata fees over and above the contractual price for obtaining title. My second objection is even if it was the case that the parties had made a bad bargain, one that became bad because of the elapse of time, such that my client was entitled to substantial sums back, that is a function of the parties having agreed to terms. And it's not for the law of restitution to try and correct that bargain. Third, point I've made before, that it would have been quite easy for the vendor to suppress a claim of unjust enrichment by pressing for performance. So insofar as he wanted to keep the interest payments, he was perfectly able to do so if he continued to press for contractual performance, rather than we did, which was terminate the contract and therefore be able to keep the properties and keep the substantial uplift in value of those properties, both properties having gone up by around $100,000 at the time. And fourthly, this not only goes very far beyond the contractual scheme, but the Court of Appeal solution, in fact, would mean that the seller would be entitled to keep, if it wasn't for the concession in relation to interest, would be entitled to keep all of the monies that had been paid.
Sorry, would be able to keep?
All of the monies that had been paid, because the mean profits would actually have wiped out any sums that we would have got back, and would have been entitled to keep the properties and the proceeds of sale. And so that would have been, my submission, a very considerable windfall to the, and that is a very considerable windfall to the seller. I think I've undershot my time by about 7 minutes. Unless I can assist you any further, those are my submissions.
No, very well. Thank you very much indeed, Mr. Watson. I think before we call on you, Mr. Robinson, I think it might be helpful for us to adjourn for a short time to consider where we are in the light of the submissions that we've heard from Mr. Watson. So we'll adjourn just now, and we'll aim to resume in around 5 minutes.
Thank you very much.
Now, Mr. Robinson, we would very much welcome your assistance, in the first instance at least, on the contractual aspects of the case rather than the unjust enrichment aspects. Particularly, can the interest payments be regarded as consideration for possession of the properties? And if so, on what basis?
Very well, my lord. My lord, Justice of Appeal Ricks in the Court of Appeal addressed the issue of the interpretation of the true bargain that the parties arrived at, that is to say, the buyer and the seller. He did that in reference to his interpretation of Clause 5 of the agreement. Now, it may be useful to look at what his lordship said in that regard. It is at page 17 of the electronic bundle. My learned friend did take your lordships to that paragraph, but it would be beneficial in my submission for the court to have a good look at what the Court of Appeal said in relation to how Clause 5 must be viewed, and in that regard, how the issue of interest must be regarded in the context of this particular contract. He says, in my judgment, it does not. That is, the question is whether Clause 5 provides for an entirely separate contract. The contracts, although not themselves providing for vacant possession, contemplate that it will be given. I say that because by providing for interest on the payment price, the contracts contemplate that although the price will be paid in installments over 20 years, the addition of interest means that the buyer will ultimately pay and the sellers will receive the equivalent of full and not time depreciated payment of the price as of the time of the contract, etc., etc. And then at paragraph 60, he goes on to say that the provisions of Clause 5 can either be viewed as providing for a collateral exercise in fulfillment of what the contracts already contemplate, or as an entirely separate arrangement, a separate contract. The reference to the need for express consent in writing to earlier possession and subject to such terms as shall then be agreed may suggest the latter. However, in my judgment, the former is the better view. The structure of the transaction makes it plain that possession by the party is intended, and that said, first, the development has to be completed before the buyer can be let into possession, and secondly, there can be marginal matters to agree at the time of possession, such as regarding who will pay for strata fees or who will insure, etc. So, and as is clear from what his lordship has said in the Court of Appeal, such a construction gives meaning to the bargain which the parties were entering into. The construction which is being proposed by my learned friends makes a nonsense of the commercial realities. As was pointed out during the course of argument, it would have meant either that the buyer would have paid the deposit, paid installments on the purchase price for over a period of 20 years without having the benefit of use and occupation of the premises. Now, the fact that the interest payments were directly referable to possession can be indicated by the fact that the payment of interest did not commence until the date of possession. The two matters were treated by the parties as being coterminous. Although the agreements were entered into, in each case, some months ahead of completion of the contracts. The buyer in each case did not have to start paying installments on the purchase price, including interest, until the date of possession. Now, this is a matter which is specifically referred to in the judgment of the Grand Court. And of some assistance on that point, and also on the question as to the effect of the agreement in relation to strata fees. Regard might be had to paragraph 5 of the judgment of Mr. Justice Williams, which is at page 116. And there his lordship states that the purchases of the parcels were both at pre-construction prices, with possession being upon closing, and with the provision of owner financing over a lengthy period of time. By the end of the hearing, it was accepted that it was later agreed that P, as may be ordinarily expected of a purchaser who is occupying a property, would be responsible for paying the strata fees over the owner-financed period. Now, that was based on evidence which was given in the case. Now, some of the matters which appear to be in issue before your lordships and may appear from the judgment of the Court of Appeal that they might not be clear. They were crystal clear to the judge at first instance, because a judge sitting in the Cayman Islands, hearing a case dealing with a contract for sale of land, especially one which is part of a strata corporation, has an understanding of a lot of the underlying principles. And the lawyers involved in that case would tend also to have such an understanding. Now, the issue with respect to the payment of strata fees is derived from the existence of a statute, the Strata Titles Registration Act. Now, that was not even mentioned in the judgment. It was because it was not an issue. My learned friend is correct that under the terms of the statute, the legal obligation to pay the strata fees falls on the owner, the registered owner of the strata lot. But of course, it is always open to the parties during the course of negotiations and coming to an agreement with respect to the sale of land or otherwise, especially for the period before there was completion and before title was transferred to the purchaser, for them to agree some other arrangement. Now, there is an indication here at paragraph 5 that part of the consideration with respect to the strata fees was that the purchases were both at pre-construction prices, which is in accordance with the case put forward by the seller, was a discount price, lower price than the normal commercial price. So that probably provides a solution to part of the mystery that we're hearing in relation to the strata fees. The strata fees, in the context of this particular contract, were not agreed to be paid by the buyer as part of the consideration for occupation, for possession. It was part of a deal whereby there was this agreement that, having regard to the special pre-construction prices at which the properties were being sold, the buyer would have the responsibility, rather than the seller, to pay the strata fees. And the trial judge provides some further assistance on that point. At paragraph 56, which is at page 138 of the electronic bundle. So that's paragraph 56 of the judgment. Here he states, the defendant, pursuant to oral agreements made between the parties for the plaintiff to pay them whilst in occupation of the parcels, also claim for strata fees paid by the defendant and for the outstanding strata fees. This is not a surprising or unusual arrangement, as a purchaser, whilst in occupation of the relevant property under an installment sale contract, would ordinarily be expected to meet the running costs of that property. In the contracts that are to be performed over a substantial period of time, often a purchaser will be required to enter into certain covenants in respect of the land. Common obligation might well be to pay strata fees, rates and taxes, if in England and Wales, and insure the property. As earlier mentioned, this is now agreed by the purchaser. So that explains the strata fees part of this bargain. It does not affect the construction, the proper construction of the contract with respect to interest and with respect to occupation. As we have said, the interest, when one looks at the bargain in the round, was payable specifically in connection with the fact that the purchaser, the buyer, would have been put into occupation of the premises. And if I may just refer to some aspect of the evidence on which His Lordship, at first instance, made that particular finding. First of all, the evidence from the seller is to be found at page 245 of the electronic bundle. And this is from the seller's witness statement at the trial, which the judge had available to him and on which he would have made his findings. At paragraph 12, at the time of the shop 10 sale agreement, construction of the unit had not been completed. As the unit was being sold to Mr. Richards at a special discounted pre-construction price, as was the case with shop number 1, Mr. Richards orally agreed that he would be responsible for and pay the monthly strata fees levied on the property by the Caymanian Village Strata Corporation. Now, that evidence was not disputed at the trial, and your lordships will see that the trial judge clearly had that particular evidence in mind when he made his brief comments or brief findings that we have seen at paragraph 5 and paragraph 26 of his judgment. Now, the buyer's evidence is to be found at page 226. And this might give some light to certain aspects of the dealings between the parties, which might not be clear at first blush. Now, first of all, my lord, as part of the background, the buyer purchased not just 2 properties, he purchased a total of 3 properties within that commercial development. The first one was shop number 1, then he entered into the agreement for shop number 10, and also now shop number 11. Now, so it was part of the background of the dealings between buyer and seller. Now, at page 226, and this is at paragraph 7 of the buyer's witness statement, he gives the history of having entered into the agreement with respect to shop number 1 back in 1994. He said, "We were considering moving location and purchasing a property for the wallpapering business, and I passed a sign on North Sound Way saying that a proposed retail development was being built and a contact number. I phoned the number and spoke to who turned out to be Mr. Henry Borden, and he said that his father had given him the land, etc. He said he intended to build 5 units, etc. Now, paragraph 8. The development came to be known as Caymanian Village. I gave him the deposit for unit number 1, which helped allow him to qualify for the loan and start the development. Once the unit was finished, I moved my wallpaper business into that unit. The understanding was always that we were going to be resident in the unit to operate my business. At the time, the option given to us of owner financing was attractive, as the banks were difficult to deal with and it was hard for me to get a loan. So this is the background to these deals. Then now he goes on to deal with units 10 and 11. Now he does not need to repeat that background which he gave in relation to unit number 1, because it is a clear indication that he's treating that as part of the flow from his initial dealings with the seller with respect to purchase of the properties in the units. The attraction to him was that he could purchase the properties at interest rates which were favorable, extended over a long period of time, which were more favorable to him than if he had gone to the bank to obtain a mortgage. Now, it unravels a slight part of the mystery with respect to why enter into such an agreement. Why was it beneficial to one or beneficial to both? If he was in a position to qualify for what is referred to as a mortgage, but effectively is to allow the bank to impose a charge on the property, then the property, title to the property would have been transferred to him. Then he would have applied, at the same time he would have applied for his mortgage from the bank, who would have their mortgage or charge registered against the property. His liability would then be to the bank and over a period of time. And if he's in default, then the bank would have its right to his rights to repossess the property and to sell the property or exercise its power, its other powers under the terms of the charge. So this was an arrangement which, in effect, approximates what his position might have been, save for the fact that Mr. Bodden, the seller, would retain title until completion. It was always in contemplation of the parties, in his own words, that he would have been in possession of the property.
What we have to work around is that, or what you have to work around is that, notwithstanding that, we have clause 5 in the terms in which it is, and one can't really say, I don't think, that clause 5 doesn't represent the common intention of the parties, because there's no application to rectify the agreement as not reflecting the parties' intentions.
Well, the answer to that, my lord, will involve us going into some of the principles in relation to unjust enrichment, because unjust enrichment allows the court to look beyond the precise terms of the contract in order to ascertain what was the precise nature of the benefit which was conferred upon the other party, which it is now being said has totally failed. And when one looks at the bargain in the round, then it is clear that what happened, as a matter of fact, in terms of the overall dealings between the parties, was that yes, they signed this agreement in these terms, but with respect to what they contemplated and what they in fact did, this document was in effect a square peg in a round hole. It did not fit the bargain which was entered into. Now,
well, of course, in the Court of Appeals, Sir Bernard Ricks, in the passages that you took us to, paragraphs 59 and 60, has sought to interpret the agreement in a way which can be reconciled with the parties' intentions as he understood them to be.
that is exactly so, my lord. That is exactly so. And if we accept, and I could take your lordships to the authorities which address that in a case involving restitution on the basis of failure of basis, the court need not be bound by the precise terms which are written, save and except where the terms of the contract prescribe something otherwise, restrict the rights of the parties in one way or another. Now, and I could just deal with this at a high level in summary. Because we have seen cases, we have been referred to the cases whereby there is provision for the forfeiture of deposit. There are some where there are provisions for the forfeiture of installments, etc. Not many, save for the Australian cases where the court had to deal with instances where there were payments of principal sums and interest. In all these cases, it appears that the courts have interpreted those specific clauses with respect to the provision with respect to forfeiture on the basis that the court will read that provision as saying that, well, where it says that the one party has the right to forfeit a certain portion, it does not treat that contract as saying that everything else is recoverable. And what the Court of Appeal, what Sir Bernard Briggs said in the Court of Appeal, accepts that in the sense that it is something which is not required to be said. In the same way, if you take the principles established in cases like Howe and Smith, even if the contract had not stated that the deposit could be forfeited, it would not have affected the right of the seller to have forfeited the deposit, because this is something which has been established in the general law over a long period of time. But so it has now come to be accepted, but that a deposit on an agreement for purchase of land is paid as earnest money to bind the parties to the deal. If there is a breach by the purchaser, then the vendor is entitled to retain that deposit. Even if the contract does not say it, then that is a right which is generally regarded in law and can be enforced. In the similar way, with respect to installments towards purchase price, the law does not have to say that the installments are recoverable, because under the general law, that is something which the court will, whether by virtue of granting relief to a forfeiture or by virtue of applying the principles in relation to unjust enrichment, will not allow the person receiving the payment or the person receiving the benefit to retain those sums paid where there has been a total loss or failure in the consideration for which those payments have been made. So,
can I ask you this, Mr. Robinson? In his submissions to us earlier, Mr. Watson suggested that in addition to the written contract that we can see, there was also an agreement which he suggested might be regarded as a contractual license for possession. So, in other words, the written contract that we have in our bundles isn't the entirety of the contractual arrangements between the parties. What your response is to that submission?
well, if the parties were to look at this contract, or if this claim had been, which I believe that was how it started, as if it is a claim which is based strictly on the terms of the contract, then there would have been no right to recover anything beyond the amounts which are specified as recoverable under the contract. This contract does not state that the purchaser was entitled to recover the installments. It does not state that. But in the context of these agreements, as stated by Sir Bernard Briggs in the Court of Appeal, it would not have been necessary for for the contract to state it in order for the court to give effect to that right of recovery. But the way how that operates, it is either by way of relief against forfeiture, if there is a forfeiture clause which governs the specific payments. In Stockloser and Johnson, Lord Justice Denning, as he then was, identified two categories of cases. One, cases in which you have a forfeiture clause. In that case, then the party who is seeking recovery of the sums, which is stated in the contract to be subject to forfeiture, could only recover the sums by virtue of seeking relief from forfeiture. And the court will grant relief from forfeiture in circumstances where it would be unjust, unconscionable for the person receiving the sums to keep them. Now, if the other category identified by Lord Justice Denning in that case, in Stockloser and Johnson, is the category where there is no provision with respect to forfeiture. Now, in this case, with respect to the deposit, there is a provision for forfeiture. With respect to all the other payments, there is no provision with respect to forfeiture. So this is how this case has to be dealt with. In order to recover that amount, using the terms stated by Lord Justice Denning, the buyer would have had to exercise his rights at law to recover the sums paid. The basis on which that right would be enforced has developed in accordance with the principles of restitution on the basis of unjust enrichment. And that is how, based on the authorities, the purchaser would have been entitled to recover the installments. On the question of the interest, then one would then have to look at how those principles are applied to see whether or not there was a total failure of basis for the payment of the interest, which then takes you to whether or not this was part of the consideration for the purchase of the price, for the purchase of the property, or whether it is entirely divisible, that it is in relation to something separate. Now, there is authority, which I have referred to in the written case, and I could take your lordships to them if necessary, which recognizes that principle of severability. My learned friend does not dispute it, because in the appellant's written case, they also acknowledge that these principles apply, and they have gone through the authorities which refer to and apply these principles. So the question in this case, well, when the court comes to determine the issue and looks at the four elements which must be established in order to grant relief on the basis of unjust enrichment, one part of the factors which the court would have to consider is whether or not the retention of the amounts being claimed would be unjust. And that was the one which was addressed by Sir Bernard Ricks in the Court of Appeal. He addressed it in a particular way, but it is our case that it was not necessary for him to have taken that route, really, to say that what needs to be done is to set off the notional mean profits, which might have been payable for the use and occupation of the property. What he could have arrived at that decision purely on the basis that the interest payments are referable not to the price for the purchase of the land, in respect of which the purchaser was entitled to have transfer of title. It relates to something else. It relates to the fact that the purchaser was being allowed to enter into possession. The vendor was deprived of use of his money, which he would have received and had use of had he been paid at the time of possession, or at the time once the construction of the buildings was completed.
I wonder if I could take you back to the terms of the contract on page 525. Now, you said before you took us to Justice Williams's judgment that the payment of installments and or interest wouldn't commence till the date of possession. Clause 3B, Clause 3A provides for the payment of deposits, presumably at the date of signing or at or before the date of signing
Yes,
of
ma'am.
the contract in December 1994. The 3B envisages that the rest will be paid over 20 years, and it provides for a date of the final instalment, not a date for the initial instalment, the date of the final instalment not having been put in. But I think we can see it wouldn't have started with 19, it would be 20-something. But be that as it may, was there evidence before Mr. Justice Williams to the effect that the agreement was to the effect that the instalments would start only on completion of the building and possession?
No, my lord. And in fact, on the evidence, what in fact happened, and this was accepted by the judge, we have to take it, was that upon completion of construction, the seller produced the interest worksheets. And that is the interest worksheet. Those interest worksheets set out the payment schedule. Now, the interest worksheet in relation to shop 10 is at page 321. And it is perhaps somewhat difficult to read, but
Well, the thing is, you see it starting from 1st of August.
it starts from 1st of August, 1995. The agreement is dated July, I think. But it was some months before the agreement, some months before the actual commencement of payment.
Yes.
That-
So then the contract provided for 20 years of instalments and an unstated final instalment date. And your position then is that the actual agreement as to the payment of instalments must have been something agreed at or towards the time of the completion of the construction and is evidenced by that schedule.
Yes, my lord.
Thank
Because
you.
what clause 5 does is that clause 5 says that possession subject to agreement in writing. But we know that the only writing which was exchanged at the time of possession was that the interest worksheets were produced, which then set out the payment schedule, and it amortizes the payments over a period of 20 years. Now, what gives a little, well, not a little, much cause for concern with respect to the position being taken by the buyer with respect to the construction of these agreements is that the buyer could have avoided the payment of interest for 20 years by virtue of paying the entire sum which was due. So, which was why it is difficult to understand a situation whereby it could ever have been contemplated that possession was not directly linked to the payment of interest. The payment of interest could have been avoided completely. The minute the purchaser paid the payment, the total purchase price in full, then that would bring the interest payments to a halt. So the longer the purchaser remained in possession, the longer the obligation to pay interest. And the question is, what else is that interest referable to?
I wonder if that, I think, rhetorical question might be a suitable moment for us to adjourn.
Yes, my lord.
And we'll resume at 2 o'clock.
Very well, my lord.